Lots of fallout from a rowdy restaurant party at Big White. The resort has terminated Charlie Victoria's lease and fired 2 staff members caught on video. Employment lawyer Jon Pinkus is joining us now. Thank you so much for being with us. Now, this is a story that has a lot of people talking. 2 staff members were terminated without warning here. So can the employer actually do that? And if so, under what conditions?
Well, the first thing I should say is a termination for cause is unusual. Typically, a termination for cause is going to require some fairly serious and fairly egregious misconduct on the part of the employees. But this may be one of those cases because you've got a situation where the employees are putting not only themselves at risk, but others at risk. They're putting the not only the safety of Big White at risk, but also the ski resort's ability to operate. They could jeopardize the entire operations of that resort as a result of their conduct. From what we know, of course, the evidence will later come out, but what it seems like happened is that these individuals were specifically told not to do this in very unequivocal terms, and they did it anyway, which suggests that what they did was intentional. So there are certainly the ingredients for a dismissal for cause without payment of termination pay here, which is, to be sure, a rare scenario. But this could be one of those scenarios.
And maybe rare also in the situation that these employees were off work, they were on their personal time. Does that make any difference here?
It can make a difference sometimes. There are certainly situations where an employee who is doing things off on their work time that doesn't have a connection to their employer could be deemed to have that kind of freedom and not have that impinge on their rights in the workplace. But here you have a situation where employees were going to be going into the workplace having put themselves at risk. And I would analogize that to someone who comes into work intoxicated. And the fact that they had gotten drunk when they were off the job, become intoxicated when they were off the job, doesn't help them. The fact that because when they're on the job, they are intoxicated, and that's when they're putting people at risk, assuming that, it's a safety sensitive position. So that's the kind of situation that I would compare this to.
And John, we all know the stakes are high right now. So what kind of lesson does this serve for other people? For example, could flouting COVID-19 restrictions even outside of your own workplace end up costing you your job regardless of what industry you work in?
Well, it's really going to depend. I mean, this seems like a particularly egregious case. Certainly, I could imagine other cases where people had engaged in conduct that's less obviously against COVID protocol, that perhaps came in a situation where the employer had not given them explicit direction not to do this, and perhaps in a situation where they're not putting others at risk, perhaps in a situation where they're not jeopardizing the operations of the business. So, just to be clear, just cause is still a very, very high standard, and it is more the exception than the rule that cause is going to be established. But if it's in a case like this where you're jeopardizing the health of others and you are disobeying a clear direction, that's going to be just cause. If those ingredients aren't there, then in many other situations, it may not be just cause. So employers have to be cautious as well, because there are consequences for doing it wrong.
Well, certainly serves as a lesson for both sides. Employment lawyer Jon Pinkus joining us today. Thank you so much for being with us.
You're welcome.